Okay. So Philip, again, thank you so much for taking this time to meet with us and allow us to ask you a few additional questions. Last time that we had a conversation, you brought up so much information that was incredibly useful both to our team, our intakers, our marketing team, and most importantly to the different leads and victims that come through our landing page and our call center looking for attorneys to help them, attorneys just like yourself. So really appreciate the time. By matter of introduction, Phillip Reid is an attorney at Sacco and Felas and has many years of experience helping victims of either personal injury or motor vehicle accidents to litigate their claim and get the absolute best compensation or settlement that they possibly can. So again, thank you so much, Philip.
Always a pleasure for you, Bastiano.
Thank you. So I have about 6 questions to ask you. So the first one is, what types of NBA cases do you see most often and what makes them complex?
So I work in New York City. As you might not be surprised, the cases that I get the most of are taxi cab type cases.
Right.
And one of the issues that's really come to the forefront the past few years is the taxi companies are their own companies, but the drivers work with Uber using Uber or Lyft or other ride sharing apps. So it
Right.
can become a little complicated on whether or not the driver is an employee of those ride sharing companies or not. Different insurance issues come up. That's probably the highest volume that I see as an attorney in New York City right now dealing with this stuff.
Right. That absolutely makes a lot of sense. And why do you consider that they're the most complex? Just because of all the different parties that are involved in litigation? Are there special laws governing possible compensation or responsibility? Are they unique to, for example, car accidents where there's only, 2 personal injury drivers or personal drivers?
Yeah, so the biggest issue is insurance coverage. The
Okay.
taxi companies have their own insurance coverage, which almost exclusively is 100,000. So you
Right.
got to assume that the individual driver has no assets, and that 100,000 is the best you can get in terms of a gross recovery amount. The
Okay.
ride-sharing companies have much higher levels of insurance. Obviously, these are multi-billion-dollar corporations,
Absolutely.
but they fight tooth and nail, and their argument is the driver is an independent contractor of the ride sharing companies.
Mm-hmm.
Without getting too deep into the weeds, there's a difference between whether or not an independent contractor is vicariously liable, such as an employer is. So
Right.
that can take years to resolve. Sometimes I've been able to resolve them very favorably. Other times I've seen cases, not that I've personally dealt with, but I've seen these cases where, unfortunately the ride sharing company does win. It seems to kind of go any which way. So
Okay.
it's difficult to explain this to the clients. You can't guarantee them a good result or anything, of course, but it's difficult to get them to understand this range of outcomes.
Okay, absolutely. That makes a lot of sense. And actually, in line with that, skipping a few questions, what tips can you give to clients or potential clients so that they can best document their case or have the most information, proof, details, communications, so that they can help an attorney like yourself get the best result?
Yeah, so this is definitely going to be a multi-pronged answer. There's a few things. One, in New York, we have a specific form known as the MV 104. It's kind of like your own police report that you can draft and fill out. A lot of the times these days, the police don't even come to the scene, so there's no police report rendered. So if that happens, it's imperative that the client fill out an MV 104 right away. Second thing I would say is to go to an attorney right away. You don't know how your injuries are going to progress. You don't know, how your body's going to feel in the next weeks or months or whatever.
Right.
The attorneys can do a lot of work for you right away, such as filling out the no fault application to get your 50,000 in medical benefits quickly, helping you with the MV 104, making sure there is a police report or not,
Right.
and looking up, information on this driver. the next thing I would say is to, of course, try to get the license plate. If you can just get a picture of it, it makes things a lot easier. It can be very difficult to identify, a defendant insurance company, a defendant driver, defendant car owner, right? They're all technically kind of different entities without that
Right.
information. And the last thing I would say is go to the doctor right away, report it, complain to the doctor, tell them you're in pain if you're in pain. A lot of people try to be tough and downplay their injuries and whatnot. Doesn't help your case.
Or they might be also in shock. And so, for example, sometimes physical injuries don't really present themselves until the next day or 2 or 3 days, also depending on kind of your overall health. In some cases, and I think we've seen one of these cases together, injuries got complicated a few months down the road, or 6 months down the road, something that possibly wasn't properly attended or treated, and then just got worse. But it was definitely the root cause was the accident. Am I right?
100% right. I've had a lot of clients tell me, I think all the adrenaline was pumping. I didn't feel anything right away. And then I woke up the next day and it was excruciating. So you're
Exactly.
100% correct. Pain and suffering can develop subsequently to the date of the incident.
Exactly, exactly. Um, this isn't quite on my list of questions, but I wanted to ask it anyways. New York and probably other states are quite large. They're large states. So I imagine for a lot of attorneys, it's difficult to help people that are in the more remote regions or, somewhere that might be 2 or 3 hours of a distance. Um, how would you as an attorney consider those cases, and what would you recommend to those victims that think, because it's so difficult to get out there and do, whether it's disposition or review of proof or whatever, for them to actually get the representation they need?
So in one sense, it's actually easier now than ever because almost everything can be done over Zoom, over the
Okay.
phone, through emails and whatnot. On the other hand, you will always need to, at least if you get into the lawsuit and you can't resolve it, you will need that client to see the other side's doctor, which has to be done in person. What I would say is do your research on, a good lawyer, contact them, explain them the situation. That lawyer should be able to work it out no matter how big the state is. They can personally go, they can send
Mm-hmm.
someone, they can
Mm-hmm.
get local counsel, someone that's a little closer to attend the court appearances. But you'd be surprised at how few in-person court appearances there really are. I had an appearance the other day in upstate New York that was virtual, and the judge was extremely nice. The other side was extremely nice. We were able to get just about all the discovery, written down into an order without having to actually physically go or the client having to physically go. So I think
Mm-hmm.
that those barriers have come down a lot because of the pandemic, frankly, and the way the practice has changed the past 5 years.
That makes a lot of sense. Is this at the discretion of the judge whether something can be virtual? Because you mentioned that the judge was nice and the other attorney team was nice. So it's at their discretion. You all have to kind of come to an agreement.
That's right. It is at the judge's discretion. You could certainly request a virtual appearance. I remember I
Okay.
had one day in February of 2023, I was supposed to have an upstate appearance. It snowed like crazy downstate here, so I can only imagine how much it snowed upstate. And
Right.
that judge sent an email saying you do not have to appear in person. So it is up to the judge's discretion. However, the attorney can always request an accommodation in that respect.
That's amazing. That's a change that came up as a result of the pandemic, right? Was that ever seen before the pandemic or not at all?
Yeah, I think it was a lot more they wanted you to be in person regardless, especially in New
Okay.
York. I have seen in New Jersey, where I'm also admitted, telephonic appearances were permitted occasionally, but the preference was always viva voce, in person, in the flesh. And that's changed a lot since the pandemic.
That's That's an incredible consideration. I don't think, well, especially IMG as a legal marketing firm that works with a whole breadth of attorneys considers, and that's something that we can also offer as a consideration, that sometimes things might not be as convenient, but there are ways to get over these hurdles and try to help these people. So that's amazing. Thank you for that. The second question, what are some misconceptions people have when seeking legal help after an accident?
Yeah, that's a great question. I would say that one, you should speak to a lawyer as soon as possible just to know your rights. But the thing is, people might speak to one lawyer and then instantly lock in with that attorney. There's no reason like seeing a doctor that you can't seek a second opinion. You can go to a
Mm-hmm.
different lawyer and just run things by them, see what their take is. If they might have a legal theory that the first lawyer didn't have, that could be all the difference later on down the line in the case as the case develops. So I would say that you're not necessarily locked into the first attorney you see. If you don't like what they say, you don't have good chemistry with them, you don't feel as though they're going to do a good job representing you, don't sign up with them just to sign up. Seek
Yeah.
another lawyer.
See. See. Yes. And actually, on that note, I think we've seen a lot of cases from the many people we've spoken to where people unknowingly entered contracts. One might ask, how's that possible? But really, they might have thought that it was just for the purpose of sharing certain medical information for an evaluation, and they didn't realize they actually signed a retainer and they're formally retained. Or just in general, different reasons. How do you think those can be avoided? How do you think that people can possibly be a little bit more careful about retaining an attorney? And then on the flip side, how plausible is it for someone to change attorneys if they have, whether accidentally or intentionally, locked themselves into an agreement with an attorney? And for whatever reason, the case isn't flourishing, or maybe there isn't quite chemistry between attorney and client for any number of reasons.
So a few different points. These retainers can sometimes have a lot of legal jargon that your layman doesn't understand. It's
Absolutely.
on the attorney to explain it to the client in as much detail as the client requires so that there is full understanding. Now, some lawyers might just hold a paper up and say, sign here. I would submit that that's unethical. If the client has any questions, those should all be addressed immediately. The client can also convey to the lawyer, listen, I'm not sure what this is. Can you explain it to me? Right? Lawyers in our defense, we're not mind readers. Sometimes you might think a client is
Exactly.
understanding, and then later on they say, no, 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 I have no idea. We have to have great, great open communication and understanding between everyone at the outset to avoid issues down the line. With
Right.
respect to people that want to switch, it's much easier than you might think. You always have the right to go to another lawyer. You always have the right to sign another retainer. The lawyers will work it out between them. And if the courts need to get involved, that's between, the lawyers and the court. It should not affect the client's recovery in any way, although it may take some time. Usually it doesn't, but it's possible it could take some time for the file to be transferred. But in the grand scheme of like a multi-year litigation, under no circumstances should that take more than a few months at most.
At most, right. So, continuing with that thought, why do you think so many attorneys are very hesitant to take clients that might have representation, knowingly, intentionally, unintentionally, or sometimes unknowingly? We have seen those cases as well. Why do you think so many attorneys are so resistant to those types of cases? And why do you think that they should reconsider?
Well, I think if someone's unhappy with their lawyer, you should always at least hear them out and see what's going on. See if it can be helped. It might be that unfortunately they just really don't have that great of a case, and there's nothing another lawyer could necessarily even do other than, potentially take over and try to settle it quickly if possible. But sometimes it's just not feasible for a different attorney to do any better, even if there are
Right,
issues. Now, communication is always key. The number one issue between clients and attorneys is lack of communication. In terms of what I hear complaints from, what I see in
right,
my practice. I think that clients need to understand that most attorneys are very busy, in court and depositions and whatnot. But by the same token, the attorneys should try to get back to the clients as soon as they possibly can and make sure the cases are moving and not languishing. We see that, I know you see that so frequently where the case languishes, client can't get through to the attorney, no one knows what's going on. and it leads to a lot of resentment of lawyers, frankly, which is not good for anyone.
Right. Do you generally find that attorneys are collaborative? For example, if a client has reached out to you and said, I really want you to take my case, do you find that other attorneys are willing to do so, or maybe a lot more resistant, or?
In my experience, generally attorneys are willing to take on cases from other firms.
Right,
It's rare that I see issues with that. The issue is just, does that client have a potentially good case?
right,
If the attorney reviews it, they might say, listen, I'm sorry, but this is just not something that we're going to be able to sink time and money into. Let's say it's a very limited insurance policy, a 25,000 is the minimum in New York, motor vehicle accident type cases. There's issues regarding how it happened. It just might not be feasible for the other attorney on their end, right? To take the time and money and invest for, what might not be the greatest case. But in general, if a lawyer sees that this person has a great case that is languishing, that lawyer will always want to scoop that case up.
perfect. I have also seen several cases where we've had people come to us and say, I did have an attorney, it did go to settlement, but the insurance amount ended and I still have pain, I still have injury, I still need treatment, I really don't know what to do. What would you recommend to prevent that? The only thing that comes to mind for me is having UM/UIM insurance, but there might be other tools that you know of. And on the flip side, if they don't have those, is there any other way to recover funds that can go towards the injuries? Going back to, for example, you're saying a $25,000 limit, sometimes that doesn't really get you very far. And so you have someone who is severely or catastrophically injured. Is there anything else that can be done to help them?
Yeah, so in New York, we have an insurance law. It's Insurance Law 5102D. Without getting into the weeds too much, what it says is that you get up to 50,000 in medical benefits. But those no-fault applications have to be completed within a few months of the actual incident. So
Right,
this is
right,
another reason why it's great to retain a lawyer right away to help you get your no-fault set up. Not everyone is aware of the no-fault benefits, and if you don't, apply within the deadline, they can be strict with allowing late no-fault applications and whatnot.
right.
There's no guarantee that you will get it. So I would say that one, you definitely want to apply for the no-fault benefits as soon as possible. Again, that's typically 50,000 in medical benefits. You would have to see the insurance company's doctor, right? A no-fault IME, but those benefits do continue even if you were to settle the case. So that's the biggest thing here in New York,
Wow.
yeah, that I would
I
say in
had no
terms of.
idea that existed. Do those also apply, excuse my frankness, in death cases, for example?
Yeah, and that's a great question. So the no-fault benefits would only apply for motor vehicle accident cases. Now,
But where the person dies, for example.
so just to be clear, are you saying that they died and then there's some benefits after that, such as funeral expenses and whatnot?
Exactly. Or, for example, if the person who passed away is a provider for his family, has two small children, I don't know, unique circumstances, a wife who cannot work in the short term, could that same no-fault benefit, $50,000, help them?
Yeah, as far as I'm aware, the answer is no. There are certain policies, there's something known as APIP, additional personal injury protection, additional no fault, basically. In
Okay.
my experience, that typically applies to lost wages, lost time from work, things along those lines, other economic benefits, or additionally, even just more medical benefits. I've never
Okay.
seen that application in a case where, the decedent plaintiff dies in a motor vehicle accident case and no fault continues to pay the family, unfortunately. So as far as I'm aware, the answer is no.
Okay, but that's so interesting. I did not know that these sources or these funds even existed. In addition to that, are there steps that the individual can take to maximize their possibilities of recover? I believe New York is an at-fault state. You, as a no-fault driver, could you also tap into your own insurance? Having UM/UIM or not having UM/UIM, could you possibly tap into any other insurance sources?
Yeah, you said it best. Getting UM or UIM coverage is key.
Mm-hmm.
Again, the actual New York insurance minimum, if another car were to hit you, is 25,000. UIM protects you if they only have 25,000 and you have huge injuries that are worthwhile more than that, or if they have no insurance, right?
Mm-hmm. Mm-hmm.
You could also look to Medicare or Medicaid if you qualify for those, or Social Security disability.
Okay, perfect. I'd like to ask you something a little bit related to a story you told me in our last conversation and also in person, where the injured party, the no-fault party, was partially at fault. And I know that a lot of states, and forgive me, I don't know all of the terminology, but I think it's comparative negligence, right? And so there's
You got it?
minimum and maximum responsibility limits. And so how do you address those types of cases, particularly in giving different scenarios we've seen at IMG, where the person insists they're not at fault, it's not really clear in the police report, or they might have been considered at fault in the police report, but the details show that actually the other party might have been more at fault. How do you review these cases and consider these cases?
So that's a brilliant question that I'll try to give as succinct an answer to as I possibly can.
Okay.
In New York, you only need to establish that the defendant was at least 1% at fault. In New Jersey, you have to establish that they're more than 50% at fault. Again, this varies by state. So in New York, it's very easy to, even if the police report is against you, to establish at least 1% at fault. Police reports are not gospel. You need to get the other side's deposition. You need to take their testimony, see what they
Okay.
say. One thing that's key is to have the attorney send an investigator right after the incident to see if there's any camera footage, especially here in New
Mm-hmm.
York City. There's cameras at so many intersections.
Mm-hmm.
A lot of
Mm-hmm.
the time, these
Exactly.
police officers are wearing body camera footage too. So if they do respond to the scene, you can try to obtain that if you have a police report and you have their names and whatnot.
Exactly.
Um,
Again, why it's important to hire an attorney immediately so they can get this investigation before any footage naturally either is eliminated or memory issues, whatever can happen.
Exactly. And it goes both ways though too, because let's say that you have a case where it seems like the liability is not that great based off of a police report or some other initial intake reason. If there's
Right.
no camera footage, then it's just your word versus the other drivers. If there's no witnesses or anyone else,
Right.
and then it comes down to credibility issues. If you have a nice, likable, credible witness, plaintiff, that's going to look good for a jury. And you can say that when you're negotiating to the insurance company, especially if they have someone on the other side that, you feel strongly in favor of putting them up on the stand. You're going to be able to rip them on cross or on hostile direct. So that
Right.
can play into your favor as well. Just
Okay.
because things don't initially seem great on liability, that is not determinative, at least in my analysis. You have to look at a potential lead or a potential case in the totality of the circumstances. What's the apparent
Hmm.
liability? Let's see how that plays out. What are the injuries? And then let's investigate if there's any insurance coverage we can go after. It should not just be, oh, it looks like it's not good. My guy might have blown a stop sign per the police report, so I'm not going to take it. Well, hold on a second. Maybe that client didn't speak English that great. Maybe that police officer got it wrong. I I've seen police reports where they put the wrong streets. There are
Right.
things you could do
Right.
to impinge upon the credibility of these police officers, and they need to actually appear at trial, which
Right.
they don't always, and they're not always subpoenaed. So again, police reports not determinative. A good lawyer can try to make, something out of most cases if it's there.
Exactly. Exactly. And actually, a small caveat to that. That's why I think having heard so many different scenarios, I appreciate so much that you're willing to reconsider, you're willing to look into the details, you're willing to put the initial time in to see if there's something you can do to help the person. Because the truth is that not many attorneys out there are willing to, and so many people get, sometimes 5 or 6 doors kind of shut at them. but there is a possibility that there's somebody who can help them. And so I definitely, would take this opportunity to say to anybody, reach out to Phillip and ask him to take a look at your case, because you're actually willing to give them that time and say to yourself, how can I help you? How can I help you get the most you can? Is there any opportunity that we can take advantage of to try to get you something for what happened? And I appreciate that.
Yeah, just doing my job. Always a pleasure.
Thank you. Let me see. I think I only have one last question. I'm not sure how we're doing with time. But my last question is, how can, take into consideration everything we've been saying, how can legal marketing help educate potential clients about their rights and their options in MVA cases, taking into consideration that legal marketers are just that, they're marketers, they're experts in marketing and in getting the message out and reaching the right audience, but we're obviously not attorneys and we don't have the studies or the background or the experience and the know-how that you guys do. So how can legal marketers do the best job to relay that information and get those cases over to you?
Yeah, that's yet another great question. What I would say is that marketers should try to be very clear and don't overpromise. I think a lot
Okay.
of people have this notion that, oh, I got into a car accident, I'm going to be a millionaire. You see so many ads with,
Yeah,
kind of misleading lawyers and whatnot,
absolutely.
directed by their marketing teams and whatnot. I think that, marketers should do their best to be very clear on what's going on and not overplay cards. The only other thing I would just add is, and I do not have a marketing background, is that I think
Right,
it's great if lawyers and marketers could work very closely together before doing campaigns and whatnot, and before making these ads and various advertisements, especially over social media now, where
right.
expectations are tempered a little bit and there's no promises or guarantees of over deliverance that cannot be met, so that way no one
Exactly.
has any false notions at the beginning.
Exactly. And that's exactly what we're trying to do at IMG, to pick your brain a little bit, get a little bit more information that if we as a marketing agency, 15 years in the legal field, don't know, imagine other people who have not been exposed to attorneys or these types of cases. And so one of our key objectives is also to educate and to impart this information that we can gather from attorneys like yourself. So again, thank you so much. Really appreciate it. I've come away from this conversation with many tidbits of information that are incredibly useful to myself, to our team, and also to our potential clients. So thank you so much again, Phil, for your time.
Anytime. We'll be in touch, Bastian. Have a good one.
Thank you. Thank you so much. You're the best, Philip. I'll let you know when I'm in New York, by the way, before we shut this down. I'll be in New York probably in November, so
Oh,
I'll
no
reach out
kidding.
to you.
Okay. Yeah, come hit me
Okay?
up. Yeah.
Yeah?
Sounds good. I'll be here.
Perfect. See you then. Take
Bye bye. See you
care.
soon.